Many wars have been waged over what we call dead left here in Jamaica, but that can be solved by drafting a simple document that is called a will. That is what we will be discussing this week on Conversations About Money with myself and my guest, Rashema Gordon Morgan. Want to see more? Keep watching. Hello future millionaires and welcome back to my channel. I am Kayla.K.Keane from Financial Literacy, here to bring you another in the series, Conversations About Money. As I said before, this week I'll be talking to attorney at law Rashema Gordon Morgan about how you can manage your money after death, or to put it simply, how to make a will. Welcome, Rashema.
Thank you very much for having me, Miss Kayla.K.Keane.
Okay. So Rashema, firstly, what is a will?
So a will is a written document that is drafted by a person, basically for the distribution of his assets upon his death. Okay. So that's simply what it is.
Okay, that's very easy. So how old do I have to be to make a will?
All right, so under the Jamaican law, which is the Wills Act of 1840, you have to be an adult to be able to draft a will, so 18 years.
Okay, so once I'm 18, I can draft a will. But most persons will say, I'm 18, but I don't have anything.
Well, the truth is, you don't need to have anything, because I realize a lot of Jamaicans, they don't write wills because they're like, oh, I really don't own anything. It could be a chupans, write it down, right? You don't have to have a lot of things to write a will. It's just to make sure that, as you have said, nobody's arguing over it once you have passed.
So I can write a will with just my bed?
If you want to give the bed to somebody, why not?
Okay. So you see, guys, you really don't need to have a lot of things to have a will. So Rashema, can it be dangerous to write a will without an attorney?
Yes, it can be dangerous to write a will without an attorney. However, you do have the option of going to a store and actually purchasing the form and completing it yourself. However, there are certain provisions that are made within the Wills Act, right, that stipulates how the will should be drafted. For example, a lot of persons don't know that at the end of each page of the will, you are supposed to, the testator is supposed to sign the will, right? That could lead to the invalidity of the will. As well as many persons may not know that once you draft another will, it supersedes the original will. So if there's anything that you have not accounted for in the previous will, then it would be null and void, right? So there are those things that persons would not know, as well as in terms of how you share certain things or distribute them to certain persons. You have to be careful of that as well.
For example, minors?
Exactly. Okay. So for minors, for example, you need to have a trustee appointed for the minors. Yes.
Okay. So you would suggest that persons use an attorney then?
It is imperative that you use an attorney.
Okay. What should I think about when I'm selecting an executor? And for persons who don't understand what an executor is, just explain what that is.
So the executor is basically the person who, after your will has been drafted and upon your death, those are the persons who would start the process for the will to be validated or approved, right, for the distribution of the property, basically. Yes.
So what should I think about when I'm selecting that person?
For an executor, one, the person must be trustworthy, right? You have to ensure that whoever you're leaving to execute your will upon your death, that person will be utilizing what is in the will. Because some persons said they didn't know of a will any at all. Right? So what you can do, instead of having one executor, you can appoint two persons.
Okay.
You can have a primary executor and a secondary executor, right? So in the event that the original executor refuses or doesn't want to go through with administration of the estate, right? Or granting for the probate of the will, I should say, then you would have the other person, the secondary executor, going through that process. You'd also want to know that even though we don't know because it's God's will, the person can outlive you or has the ability to outlive you. So you might want to choose somebody younger than you, right? But the person also have to be an adult.
Okay.
That is very important as well. Yes.
I was just thinking about friendships when you said that you should ensure that you choose somebody who is trustworthy and choose two
Yes.
if possible. And I was thinking, what if I was friends with someone and then we're no longer friends, but I wrote my will 10 years ago and I forgot to change it? So it's really important to choose two persons,
Yes,
so you
that's
could have
correct.
somebody in the event that
That
does
happens.
happen.
Correct.
Right. How do I ensure, though, that the will is valid? So I write the will. Maybe there are persons watching now who have a will.
Yes.
But how do I ensure that it is valid?
All right, so there are a few things that you need to know when you're drafting the will. So first of all, the act says that the will must be in writing. So that's the first thing.
Oh, so you can't be fancy and type it up.
It must be recorded. So you
Okay.
can type it,
Mhm.
you can write it, but it has to be something you can see on paper.
Okay.
Right?
Mhm.
The other thing that you need to ensure is, as I said before, the signing of each page.
Okay.
You also have to remember that at the end of the document, right, when the testator signs the will,
Right.
nothing should come after that. Anything that comes after that is null and void.
Okay.
Right?
Mhm.
There has to be two witnesses when the testator is signing the will. If two witnesses are not present at the same time for the signature to be there, the will is not valid. So it has to be signed and has the same date for all three persons as
Okay.
well. Yes.
That was a belly full so far, and I'm really enjoying the conversation.
Thank you.
But Rashema, what is the recommended way for me to store the will?
All right, so you have options, right? If it is that you have the will drafted by attorney or an attorney, then the attorney can actually keep it for you, right? If you have, for example, a fireproof or waterproof safe, you can utilize that as well. You can also think of keeping it in a cool and dry place, or
Right.
you can give it to someone that you trust for safekeeping in the event of anything. Yes.
So if I give it to somebody, should I communicate with other people and make them know that
If
this
you
person
want,
has
because
the
you
will?
don't want it to be a case where only one person knows of the will, and then up in the event of death, then nobody else, everybody's just wondering, did she have a will, did she not have a will? Also, you can actually rent a safety deposit box at any of the financial institutions
Oh.
to store your will as well, or
Oh.
any documents that you may have. Yeah.
And I guess you should give somebody a key for that.
You can if you want to, not necessarily. No.
Okay. So for those who do not have a will, how will the court disperse their assets after they have died?
All right. So there's a difference. So when it is that you die, leaving a will, then what we do is called a grant of probate, right? Because you have a will.
Right.
In the event a will is not available or it's not known of the will,
Right.
Then what you'd have is something called application for letters of administration. All right. So that would be the application for letters of administration. If it is that minors are involved, then you'd have to go through the Administrator General, because what is going to happen is that when the assets are distributed, a portion which is left or will be assigned to that child will be given to them on basically a monthly basis or as the need may arise for their medical expenses, educational expenses until they have attained the age of 18. Okay, so the residuary estate will be passed to the surviving persons of the deceased, right? So if the person dies leaving a spouse, whether it be common law or a legal spouse per se, let's put it that way, then half would go to the spouse, and then where there are children involved, the other half would be shared equally amongst them.
Okay.
Now, say for example, it's a spouse and an only child, then it would be 2/3 for the spouse and 1/3 for the child.
Oh.
Yes. Now, there's also something you must remember. For common law spouses, you have to prove that you are actually a spouse
How
to
do
be
you
able to
prove that?
benefit. So you'd have something, an affidavit, which is basically a document that you're going to write stating that you've been involved with this person for a period of 5 years or more,
Okay.
which is what the law states, that you have to be
For-
in a relationship
for
for 5 years or
years
more
or
to be a
more.
common law spouse,
Right.
To state you've been living together for that time and you've been in cohabitation, whatever the case may be,
Okay.
right? Also, if there's no spouse and the person leaves children behind, then the children absolutely take everything.
Okay.
In the event that the spouse and parents survive, then the spouse would get 2/3, and then 1/3 goes to the deceased parents.
Okay.
And then it goes down the line to siblings, etc., as the case may be.
Yeah.
So that has to be considered.
Okay.
Right? I also, let me just interject right here to say that where the person has siblings, or say for example a father dies and he has his children, but they're grown children and they would have passed leaving their children,
Right.
right?
Mm-hmm.
The grandchildren can take the parents' share
Oh.
of the
Oh.
estate.
That's
Yes.
pretty cool.
Yes.
Yeah, but I think in all that we're saying, it's probably best
To write a will.
to write a
To
will.
write a will.
Yes.
It is, and as a matter of fact, you have to think of the cost as well. It is much more costly to get the letters of administration done.
As opposed to just writing a will.
Exactly.
Which is pretty affordable.
It is. It
Yeah.
is. Yes.
And additionally, what if I get married today, right?
Mhm.
And I wrote my will yesterday?
That
Because I
is a-
don't think people understand
Yes,
that.
that is a very good question, because a lot of persons think that the will still stands.
Yeah.
No, no. That will automatically is rescinded once you get married.
Right.
So you need to draft a new will.
Right. Thank you for watching so far. And if you have gotten to this far in the video, comment "I have a will" down below and confuse the others. So a lot of people will say that they do not want to write a will just because they are young or they think they have nothing. What are some of the things that I can actually put on my will?
All right, so first of all, this idea that you're too young to have a will, just throw that out the window. Once you're age 18, you have anything in your possession, write a will. So for example, if you purchased a car, you can state that the car is supposed to go to X, Y, or Z, or the person supposed to sell the car, your executor should sell the car, and then the money could go to whoever you want it to go to as well.
Right.
If you have any bank accounts, state who the money should be willed to. If you have any insurance policies, what should happen to that money upon your death. For example, firearms. So say, for
Right.
example, you're a licensed firearm holder, right? You can state in your will that the firearm should be sold, and then the monies that are received from the selling, from the sale,
Yeah.
yes, the monies that are received from the sale, then that money can be placed in an account for your daughter, your son, whoever the case may be. So it doesn't matter what it is, ensure that you have a will. If you purchase property, for example, ensure that you devise the property properly, right? Because you don't want it to be a case of upon your death, persons are arguing over who should get
Exactly.
this part of the land, who should not get the land, or whatever the case may be. Always have a will. No matter how small it is, draft a will.
Okay. What about your burial? This is a very unique question, but I've always thought about it.
Oh,
What if I
no.
want to be buried in a specific way, or if I want to be cremated? Can I include
You
that?
can include that in your will as well. So you can state that, for example, you have a bank account with some money in it, right? And you don't want your family to be wondering how your funeral expenses are going to be covered. You can state in your will that this particular account at this particular branch or financial institution is to cover my funeral expenses, as well as, okay, I want to be cremated, I want to be buried, whatever the case may be. If I'm cremated, I want my ashes to be spread here or there.
Okay.
Yes, you can also state that in your will as well.
Okay. That's actually pretty interesting. And guys, you might be wondering why we're talking about will, but this is all about manage your money after you have died. So I taught you how to manage your money while you're alive, and I'm teaching you how to take control of your finances when you have passed too.
Yes.
So is there any other thing that we should talk about?
Yes, for example, I didn't mention this earlier. Now, something that is very important when you're thinking of drafting a will, you must have the mental capacity to draft a will, right? Because you need to ensure that the person who is devising when you're devising your assets,
Right.
is the person sane? Yes, you need to be sane. Your executors need to also have mental capacity as well,
Okay.
right? So for persons who are on their deathbed and they may have gone a little senile and they want to write a will, persons who are living or who have survived the deceased, then they might question the validity of the will, stating
That's
that
very
the person
true.
doesn't have the mental capacity to do so.
Very
You must also think of the fact that It doesn't matter how many wills you write, because once you draft a will, it automatically rescinds the previous will. So you can draft a will as many times as you want. There is no limit.
So you would suggest destroying the old one then?
Yes.
Okay.
It is important that you destroy, because then you don't want it to be a case that upon your death, persons are arguing whether this one is the correct one or that one is the correct one, because it could be a case where upon your death, someone finds a will.
Right.
Right? And that will is probated.
Okay.
Yes? And then after that will is probated, they find another will which has a later date than the will that was probated.
Right.
You don't
That's
want that.
quite
confusion at all.
problematic.
Yes, that is going to be problematic. So always destroy the previous will.
Okay.
Yes. But yes, I think those are some things that persons need to consider.
Okay. Well, I think this was a really good conversation, and you should benefit somewhat from it. If there's anything that we missed out, comment down below and we'll talk about it another time. But guys, I know you might want to speak to Rashema more, and I can tell you, you'll get the best service ever from her. And if you want to draft a will, she could do it for you. So Rashema, how can they contact you?
All right, so first of all, there's my Instagram page, which is rgm.law. You can also contact me via email, which is rashema.gordon@gmail.com.
Okay.
Yes.
All right. So if you didn't hear the information, I'll link it in the description bar so that you can definitely reach out to Rashema and get started on the journey to managing your money after death. Now, until next time, I am Kayla.K.Keane and Rashema Gordon Morgan.
Thanks for having me.
Telling you bye-bye
Bye.
until next time. And remember, guys, stay financially literate.